Anil Divan, very distinguished senior advocate and currently the president of the Bar Association of India. Mr. Divan started practice in the Bombay High Court way back in 1952 and has been practicing in the Supreme Court since 1979. He's been asked to play an important role as Amicus Curiae by the Supreme Court in public interest litigations in a large number of corruption cases involving cabinet ministers, members of parliament, such as in the Jain Hawala case, the Chandraswamy case, and the Indian Bank scam case. Ladies and gentlemen, a round of warm applause for Mr. Anil Divan.
It's a pleasure and a privilege to be invited to participate in this seminar organized by Moneylife and the Bombay Community Public Trust. May I thank Suchita Dalal, Devashish Basu, Harsha Parikh to have invited me. Let me first tell you a case about the RTI Act, which I consider to be a seminal case. On 7th of May 1997, the Supreme Court judges met under the leadership of Chief Justice J.S. Verma and passed a resolution unanimously. And that resolution was that all the judges of the Supreme Court will disclose all their assets and new acquisitions in a confidential way and lodge them with the Chief Justice of India. Subsequently, there was a conference of Chief Justices of all the High Courts, and they agreed that a similar procedure will be followed also in the High Courts. Every judge will give his assets, dependent spouse, leave it with the Chief Justice, which is to be held confidentially. That was 7th of May 1997. Then comes the 2005 RTI Act, Right to Information Act. So one, Agarwal, who is a very strong RTI activist, asked a question to the Supreme Court registry. And the question was only this: have the Supreme Court judges and the High Court judges complied with this particular resolution, and have they given their assets to the Chief Justices, respective Chief Justices or not? And this came up before the Information Commission. And in January, I think it was January 2009, if I'm not mistaken, our friend Habibullah was presiding as the chairperson, and they boldly rejected the contention made on behalf of the Supreme Court Registry. Because the Supreme Court Registry said, under the directions of the then Chief Justice of India, K.G. Balakrishnan, we are constitutional authorities, we are not public servants, we are not public officials. They said, no, you have to disclose this. And not disclosure of assets. Have you complied with this resolution? That was the only question. So this was, I think I congratulate my co-panelists for this very independent judgment. Now what happens next? The Supreme Court is dissatisfied. K.G. Balakrishnan issues a statement. The Chief Commissioner is wrong. He has no business to pass this order. So the Supreme Court files a writ petition in the Delhi High Court, one of its registers. Can you imagine that Supreme Court goes to the Delhi High Court through one of its officers? Ravindra Bhatt was the single judge. Now by that time some developments took place. Veerappa Moily was very keen to help the judges. So he moved a bill in Parliament to say yes, they will disclose but they'll be kept confidential. Unfortunately, the bill didn't move forward because of opposition. Both Arun Jaitley spoke against it, Ram Jethmalani spoke against it, and some Congress members also spoke against it. So it couldn't go forward. And by that time, in August I think, they said yes, we will disclose, because they felt that Parliament protection was not forthcoming now. But still they persisted in the Delhi High Court. Ravindra Bhatt again confirmed the order of the Commission and went further. It is required under Article 19(1)(a), freedom of speech and expression. Supreme Court was not satisfied, so they went in appeal. In appeal, Chief Justice Ajit Prakash Shah, Justice, I forget the name of, Justice Murlidhar and Vikramjit Sen, yes, confirmed the judgment of the single judge. The Delhi High Court Bar Association supported the judgment against the Supreme Court view. So you see, aren't we a vibrant democracy? The Commission gives a judgment against the Supreme Court. Single judge of the Delhi High Court says no, Supreme Court is wrong. Full bench of the Delhi High Court says yes, we confirm this is completely wrong. In spite of this, the matter has been carried by the Supreme Court registry to the Supreme Court itself. So now they are going to decide this case and we are all looking forward to it. Maybe the bar will also intervene, or it may now be dropped as it's become now academic. They have put it on their websites, etc. Now, today, the thing is RTI and the way forward. Now, having said this, I have a little different viewpoint from my co-panelists about what the Prime Minister said. First, Moily says that this Right to Information Act is creating a lot of mischief. Then Salman Khurshid says, how can you lock up all these businessmen? If you lock up these businessmen, how will we grow? So that's Salman Khurshid. Pranab Mukherjee, after having released the note, his department, he says, yes, it is causing grave damage. Now, the Prime Minister has spoken after all this orchestration by 3 ministers. And what was the necessity today? RTI Act is very nicely done. So the point is, honest officers are afraid of expressing their views. The candor of official communications is lost. Now, this argument has been negated by the Supreme Court as far back as 1981. In England, even earlier than that. And I'll tell you the case, a very interesting case. After the emergency, Mrs. Gandhi comes back to power in 1980. And then 2 judges who were appointed as additional judges were not confirmed because they were seen to be more sympathetic to the opposition. So, a public interest litigation was started. On behalf of the Bombay Bar Association, Sirwai had gone, stayed there pro bono for a number of days. And there, the question was whether the additional judge who was not confirmed had a reputation which was not quite good on integrity. The Chief Justice of the Delhi High Court was Prakash Narayan. He said the reports are not good about him, I don't recommend him for confirmation. Chief Justice of India, Y.V. Chandrachud, said no, I have nothing against him, he should be confirmed. The Law Minister follows the Chief Justice of Delhi, Shiv Shankar, and not the Chief Justice of India. And the matter came up before the court. And one of the issues on which we are interested is, they claimed privilege. They said communications between the Chief Justice of India, the Chief Justice of the Delhi High Court, and the Law Minister are confidential and privileged and ought not to be disclosed. The Supreme Court, 7 judges sat, the leading judgment is by P.N. Bhagwati. They overruled this and said this is no answer. If a Chief Justice or either of the High Court or the Supreme Court has behaved improperly or irresponsibly, there is no reason why the public ought not to know that. Because the public must know what is happening, what they are doing, and what public officials are doing. And he cited something which James Madison had said while framing the US Constitution, which has now been endorsed by our Supreme Court. And it runs like this: knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power knowledge gives. A popular government without popular information or the means of obtaining it is but a prologue to a farce or a tragedy or perhaps both, unquote. Now this is endorsed by our Supreme Court. We don't want a farce, we are already having a tragedy. Now what is the way to go forward? Now after the Prime Minister's speech and the speeches which have sort of gone before what he said, maybe the title, The Way Forward, is How Not to Go Backward. I would say how not to go backward. Because government is now thinking of diluting the provisions of the RTI Act, which we should all very strongly resist, notwithstanding what has happened. But why are they reacting? What was happening all this time? Only after 2010, 2G scam broke, another scam broke, a third scam broke. They have suddenly become conscious that this act is acting in a manner which is trying to come in the way we are governing, and what we are doing is right. Now this is I think the subconscious thinking of the government and those in power. They want a dilution. They don't want to strengthen it. And if my friend is right, I'm sure Prime Minister, after the criticism which has come in the press today, I suppose you have read the morning newspaper, will clarify and tell us, if he means it, that no, we want to strengthen it and not dilute it. So please see this correspondence between Chief Justice of India about the integrity of an additional judge, the Law Minister and the Chief Justice of the High Court was directed to be disclosed. No confidentiality. There is no security angle. No, there is no terrorist angle. There is no financial angle at all. So there is no reason why it should not be disclosed. Now the way forward. Now today what do we have? We have the Right to Information Act. I get information. I find prima facie something wrong has occurred. I find something has been misappropriated. What does a citizen do? Because we are thinking of the way forward. So what does a citizen do? He goes to a electronic channel, television channel, or he goes to a journalist like Suchita Dalal, or he goes to court on a PIL. Now all these remedies are wholly unsatisfactory. Why? Because of time constraints, because of the constraints of resources. Courts do not have time to go into all this. They have to do so many other work, private litigations, public litigations, etc. So today, you get information, but the way forward is now how to deal with that information. Not only how to deal with that information, how to bring about results coming out from this information which are beneficial to good governance. And I would say 3 or 4 things. First, we must have an independent anti-corruption agency which can investigate, which is not subordinate to the executive. I consider this the most important. Independent police force, investigative force, which is not subordinate to the political executive. 2, a strong, credible, effective and independent Lokpal or Ombudsman, which we are all fighting for. 3rd, a broad electoral reforms. And finally, and most importantly, we must have cooperation from industry and business if we are to go forward. And in this connection, 2 statements have been made by a group of 14 which I read, October and January, where they support Lokpal. They also want to see that corruption is reduced, etc. Now, the onus is on them. They have to come out with some code or some norms or some standards. Because, of course, support is always there, but what are we doing about it? What are the businessmen going to do about it? And there is a very important precedent. The Transparency International was started by a person who was working, I forget his name, who was working in the World Bank. And he found that unless multinational corporations cooperate, at least to some extent, it is very difficult to carry forward a program of reducing corruption right across the globe. Because there are so many Lockheed scandal, Prince Bernard resigned, all that is documented in so many American books. So this is very important. Now, before formulating the question as to how to have an independent agency, let me tell you what are the checks and balances today under our constitution as far as the political executive is concerned. The first and foremost is the judiciary, the higher judiciary. Why? because it can question, invalidate, annul an administrative act or even legislation which is violative of fundamental rights or otherwise unconstitutional. So judiciary is one great pillar, one great check on the political executive. The second check is the Comptroller and Auditor General of India, CAG. You see what the result of his reports are. The third is the Central Election Commissioner, the CEC. All these three positions are constitutional positions, and the persons who are occupying these positions cannot be removed, cannot be transferred, are not under the political executive. If you want to remove the CAG, you have to follow the same process as removing a Supreme Court judge. That is impeachment, parliament, which becomes a public debate, etc. So the CAG cannot be removed except by impeachment. The CEC, Central Election Commissioner, cannot be removed without an impeachment. No Supreme Court or High Court judge can be removed without impeachment. Now all these are safeguards to see that these three agencies are independent of the political executive. Now do we have a similar anti-corruption agency? Because corruption is a major problem. No. We have what is known as the Prevention of Corruption Act and the CBI, the Central Bureau of Investigation, which functions under the Delhi Special Police Establishment Act. Now, it's working under whom? It's working under the Department of Personnel. And where is the Department of Personnel? The Department of Personnel is under the PMO. So, the anti-corruption agency are going to investigate their own bosses? This is the position. How do you, suppose you are in any organization and you have got an employee, because these people can be transferred, etc., etc. How is the employee going to investigate his boss? No, it can't be done. And people don't know about this. After the Bofors case, a single administrative directive was issued that the CBI cannot go forward with any inquiry or an investigation without the permission of the central government. So if you make a complaint or give information, they can't even inquire. They can't go into it. Now this was struck down in what is known as the Vineet Narayan or the Jain Hawala case, which I did as an Amicus Curiae. It was struck down, the administrative decision, in December 1997. What happens? Chief Justice Verma, Justice Bharucha and Justice Sen were on the bench who struck it down. So what happens thereafter? Thereafter, in 1998, the Vajpayee government brings out an ordinance where the same directive is put in a section. And what is the section? The CBI, without previous approval of the government, cannot even commence an inquiry or an investigation. So the people who are to be the accused, the potential accused, are going to give a permission to investigate. Look at the irony of the whole situation. We challenged it because Justice Bharucha was then still there in the court. And then when they saw that this is likely to be struck down, they amended the ordinance by another ordinance. Then Justice Bharucha retires, and in 2003, the CVC Act is referred to a parliamentary committee, headed by whom? Not by anybody from the NDA, not by the Vajpayee people, but by Sharad Pawar. Sharad Pawar is the head of that committee. And what does the committee recommend? The committee recommends the insertion of Section 6 capital A in the Delhi Special Police Establishment Act, which says, and it's still in the statute book, it's under challenge, against an officer of joint secretary level or higher, the CBI cannot start an inquiry or an investigation without prior approval of the central government. It's on the statute book after all this history. So politicians of every hue are not willing to submit to an independent, investigative, anti-corruption agency. Now this 6A is under challenge. It is before a constitution bench. Let's see what happens. It may be upheld, not upheld, I do not know. But in the parliamentary committee, Kuldeep Nair put in a very strong dissenting note, saying, how are you reviving this which has already been struck down? But nothing doing, unanimously passed by Parliament on the statute book. Now therefore, the first important thing is, should we or should we not have an independent anti-corruption investigative agency on a par with CEC, CAG, judiciary? Unless you have that, it is impossible. The way forward is to get that. And the attempt to put in a Lokpal with an independent investigative arm, anti-corruption department of the CBI to be moved there is absolutely essential. Now what did the President say? The President said this on 14th of August 2011, and I am quoting her, Pratibha Patil. Corruption is a cancer affecting our nation's political, economic, cultural and social life. It is necessary to eliminate it. And the Prime Minister in 2009 reported in the Hindu said this, in a conference of the Anti-Corruption Bureau of the CBI, he said this, to pursue aggressively high-level corruption and change the perception that while petty cases were quickly tackled, quote, the big fish escape punishment. So the CBI, the Prime Minister tells the CBI, please catch the big fish. Now, I am reminded of a famous saying by Kautilya, Chanakya. Some of you must have seen it. And this is what Chanakya says, as far as 3,000 years back or 4,000 years back. Just as a fish moving under water cannot possibly be found out either as drinking or not drinking water, so public servants cannot be found out while taking money. Very difficult because they are swimming with so much money. Are they swallowing it or not swallowing it? Nobody knows it. Now this is Kautilya. So we have a very long tradition of public officials taking money, 3,000, 4,000 years old. Now here, the difficulty is this. We have to catch the big fish. The Prime Minister tells us, please catch the big fish. But the fisherman, namely the CBI, is controlled by the fish himself. Huh? What do you do now? That's the way to go forward. And I am again reminded of what President Charles de Gaulle, you must have heard of him, Charles de Gaulle, the famous World War II Field Marshal, he became President of France on 2 occasions. And he said this, a good politician never believes what he says. And he is very distressed when others believe him. So I don't know what the Prime Minister wants to say. Does he want to catch the big fish or not? Let us see what he does in the future. I don't think with his cabinet colleagues' reactions which have come into the press, he is going to strengthen the RTI Act. Far from it. And if he follows the dictum of Charles de Gaulle, well, we should be very, very careful about what is going to happen. So this is an important thing. Now, having said this, I would also like to tell you a few things about the Lokpal bill, and which I consider to be very, very malignant. And I'm using the word very carefully, and I'm going to only give you, in the short time at my disposal, 4 or 5 malignant things. First, you must have a good Lokpal. The chairperson must be above a man of outstanding integrity. So the selection committee in the government bill is important. And what is the selection committee in the government bill? 5 under the thumb of the government. 4 others. And who are the 5? Prime Minister, a minister nominated by him, the Speaker of the Lok Sabha, who is of course belongs to always the majority party, 1 eminent jurist, and we have a lot of eminent jurists whom you all see on the TV channels all the time. So 1 eminent jurist and 1 public figure. So 5 from the government, Prime Minister or the ruling party. 4 others, some judges, leader of the opposition at all. Now as compared to that, the Jan Lokpal Bill 2.3 version says you should have the Prime Minister, the leader of the opposition in the Lok Sabha, 2 judges of the Supreme Court elected or selected by the entire collegium of Supreme Court judges, 2 High Court judges, again to be selected by a collegium of all the Supreme Court judges, and then the CEC and the CAG. I think if one wants a credible Lokpal, 2.3 version, the Lokpal version, the Jan Lokpal version seems to be better. We cannot go on the basis of a good person being there today, because in a democracy, the electorate and the citizen must always have distrust of the government, because power corrupts, and absolute power corrupts absolutely. So this important thing is, whom will you appoint, how he will be appointed. Look at what has happened. You had a good chief commissioner, you had a Session. Session raised the CEC to a very high level. You have got very distinguished chief justices who have raised things to a very much higher level. Sometimes there are highs and troughs. So this is, we have to look at all these things and do it. So that's one. The second is exclusion of the Prime Minister. Should the Prime Minister be excluded? Now the Prime Minister has been saying, oh, I want to be under the Lokpal, but my cabinet colleagues are telling me not to do it. So I am now following what my cabinet colleagues are doing. Now under our constitution, and this is very important, for those who are interested, I have written an article in the Hindu on this. Under Article 361, immunity from criminal proceedings is only given to the President of India and the Governor and earlier the Raj Pramukhs, not the Prime Minister. So the intent of the founding fathers was not to give immunity to Prime Ministers or Chief Ministers. And what is the reason? The reason is that the President is a constitutional head. He is not actively doing administration at all. He follows the advice of his cabinet. Similarly, the governor has to follow the advice normally, except in exceptional circumstances, of the cabinet at the state level. So they are not active politicians. So active politicians, if you are, then you are in the hurly-burly of politics. You can collect a lot of money. Prevention of Corruption Act will not apply to the Prime Minister. He writes a letter to all the businessmen that unless you do it, tomorrow I'm going to have raids against you. He can't be prosecuted. Why not? And we have democracies like Japan, Israel, where prime ministers have been sent to jail. Tanaka was sent to jail, Obert was sent to jail. Berlusconi today is facing serious charges, etc. He's still continuing, but still he is not above, he is not to be given immunity. So this is a very important thing. Because tomorrow a prime minister says, I will have all the portfolios, all my other ministers will be sort of also share my portfolio. And you can't go against the Prime Minister, then what do you do? And it's not something which I am saying something out of my hat. We had in Bihar for about 10 years or 8 years. It can, we have to think of all the possibilities. So the second thing, should the Prime Minister be there or not? The third and fourth things are clauses 23 to 29 of the government Lokpal bill, which gives at that during the investigation by the Lokpal, opportunities of being heard to the potential suspect or the potential accused. Now, under the Criminal Procedure Code, suppose an FIR is lodged, then the police investigates as it likes. You don't have to call the potential accused and give him a show cause notice that should I now investigate against you. There are 5 or 4 instances where under clauses 23 to 29 of the government bill, even before the adjudication starts, opportunities to be given, material is to be supplied, completely undermining the investigation. In no country in the world, the police calls the accused and says, oh, this is the material, do you have to say anything? Unheard of. This is the most, I would say, the most malignant provision in the government bill. And it's all being drafted by lawyers, don't they know it? They know it. They put it there deliberately. So if this bill goes through and this clause goes through, Lokpal is totally ineffective. Then you have clause number 17. If clause number 17 goes through, then Moneylife, which collects money from the public, will also become a public official. Can you imagine that? Not totally financed by the government, financed by the public. It is deemed to be a public official. And the Lokpal can go against it and anybody can make a complaint against it. So this is merely an idea with a view to blackmail NGOs who are really in the forefront of this fight against corruption. Any NGO can get, if it's an 8IG case, you can get money from the public, you got income tax exemption, so you become liable under the definition to be proceeded against by the Lokpal. And Lokpal, what Lokpal? Lokpal nominated by 5 people who owe their position to the government. So it's, you see how difficult it will be. This is again a very, very difficult position. Lastly, CBI is still to continue. The demand of the Jan Lokpal bill is that the anti-corruption department of the CBI should be moved to under the Lokpal. Or we move the entire CBI if you want to. And why? Because unless, as I told you, you have an independent anti-corruption investigative agency, an independent cadre, it is impossible to investigate or go against the big fish. Today, they are officers who are drawn from various cadres, Tamil Nadu, Gujarat, West Bengal, they come in, they can go back, they can be transferred, except the person who is in charge, because now some protection has been given to the director for 2 years or 3 years. Otherwise, everybody is subject to transfer, and a person who is there naturally looks to his future career. What is going to happen? He cannot displease his own bosses, he cannot go against powerful ministers. Look at the 2G scam. Only DMK leaders are there. Nobody from the Congress government. Not a single person has in the political parties on grounds of corruption they have been removed, either it's BJP or any other party. Nobody. So the political climate, whatever they may say in public, they are not in favor of a strong, credible, effective and independent Lokpal. This is the way forward. We have to fight this and we have to fight for it because there are going to be innumerable difficulties. As it is, there will be dissensions, Sam, Dam, Danda, Bhed. All these tactics will be used. They have already started using it and therefore I think the pressure, and this is a great thing which Anna Hazare has done, we were all cynical. We didn't know what to do. All of us, we had no leadership. At least now there is a focus. We have not only a focus, but we have a feeling that things will move forward if public opinion comes out in a big way and influences their chances in the next election. And this is what happened after the Jain Hawala case. Jain Hawala case, as you remember, several people after the diaries were saying had to resign. 3 cabinet ministers resigned, 2 governors resigned, and Narasimha Rao, the Congress, was reduced to 1/2 in the election which occurred in 96 or 95 or 96 or something like that because of this. So it will have an impact unless it is diffused in a manner which we are unaware of. Now finally, friends, I think we have to be very obliged to our constitution makers, obliged to the courts for upholding our right to free speech. Because look here, today I am able to come here and talk about the Prime Minister, I am talking about the political parties. Each one of us have this great right, the freedom of speech and expression. Look at what is happening on TV channels. They are going hammer and tongs when things go wrong. Look at the journalists. So this is something which is worth preserving. And the right to information is an emanation from the freedom of speech and expression. And before I conclude, friends, let me tell you a story, my favorite story. Some of you might have heard it on freedom of speech and expression. Have you heard of Dr. Christian Barnard? The famous, who in 1967 performed the first heart transplant surgery. He was a South African doctor. So in 67, the Cold War was at its height. And in his honor, because of this great successful transplant operation, though his first patient only lived for 2 weeks or something like that, the next one lived for a year or so. He was honored. and they called a conference of surgeons, famous surgeons in Europe. So a surgeon came from the USA, a surgeon came from UK, and a surgeon came from the Soviet Russia. And then Barnard was first asked, what do you consider the most difficult surgical operation? So he said, look, a heart I have done, heart is okay, but brain surgery I find most difficult. Then the US surgeon was asked, he said, no, brain we can do, but heart is very difficult. Then the UK surgeon was asked, he said, no, we find this kidney most difficult. Then the Soviet doctor was asked, he was very shy. He said, no, I don't want to answer. He persisted that you please ask him. So he said, no, what's the most difficult surgery in Soviet Russia? He said, no, I don't want to answer. Then he was persuaded to answer. So he said, tonsillitis. Everybody was shocked. Why tonsillitis? Because in Soviet Russia, nobody opens his mouth. So, we have to do it from the other side. Thank you, ladies and gentlemen.